Essentials of crime. Having gone through the above definitions, it is clear that the chief elements of crime are: number 1, a man is under a legal obligation to act in one way. Number 2, that man has an ill motive and he acts in furtherance thereof. Third, that act results in injury to another man or to society. Elements of crime. Crime refers to an action or omission that is deemed illegal by law and is punishable by the state. It is an act that violates a law established to maintain public order and protect the rights of individual and society. The main elements of crime can be described as under: number 1, legality. Legality means that an action or act can only be considered a crime if it is explicitly defined and prohibited by law. No human being can be prosecuted for an act that wasn't illegal at the time it was committed. This principle is based on the doctrine of legality, nullum crimes sine lege, which means no crime without law. Actus reus, guilty act. Actus reus refers to the physical or external component of crime. It is the guilty act or the physical action that violates the law. The actus reus can either be a commission or an omission. For example, commission. In a case of theft, if a person takes someone else's property without their consent and with the intent of permanently deprive them of it, the action of taking the property constitutes the actus reus. Omission. A parent who fails to feed their child can be held criminally responsible for the neglect. The omission, failure to act when they are legally required to provide food, is the actus reus. Mens rea, guilty mind. Mens rea refers to the mental element or the guilty mind of a crime. This is the intention, recklessness or knowledge that the individual had when committing the criminal act. Mens rea helps to distinguish between intentional harm and accidental harm. The levels of mens rea can be discussed as under: intention. The individual actively desires the consequences of their action, that is, someone who plans and carries out a robbery. Recklessness. The individual is aware that their actions carry a risk of harm, but disregards that risk, that is, reckless driving causing an accident. Negligence. The person fails to meet a standard of care leading to harm, that is, doctor misdiagnosing a patient due to careless oversight. Concurrence. That is the fourth point, that is concurrence. For a crime to occur, actus reus and mens rea must occur simultaneously. The individual must have had a guilty mind, that is mens rea, when they perform the guilty act, that is actus reus. If either the intent or the act is missing, no crime can be proven. For example, if a person accidentally hits someone with their car without any intent or recklessness, that is a sudden brake failure, there may be no mens rea. Though there was an actus reus, the act of hitting someone, the lack of criminal intent means no crime occurred. Example of concurrence. A person plans to steal from a shop and does so. The guilty act, that is stealing, and the guilty mind, that is intent to steal, occur together, establishing the crime. Fifth, harm. For an act to be classified as a crime, it generally must cause a harm, either to an individual or to society. The harm can be physical, like injury, financial, like fraud, or societal, like pollution. Causation, that is sixth point, causation. Causation requires that the criminal actus reus, must have caused the harm or result. This establishes a clear link between the defendant's action and the harmful consequences. If the defendant's action did not cause the harm, they cannot be held liable for the crime. Seventh point, punishment. For an act to be considered as crime, it must be punishable by law. The legal system determines the consequences for each crime, which may include fines, imprisonment, community service, or other penalties. The existence of punishment differentiates crimes from civil wrongs, where the goal is often compensation rather than punishment. The above elements of crime are essential for establishing criminal liability. They provide a framework that ensures individuals are only held accountable for acts that are both wrongful and blameworthy. Various stages in the commission of a crime. Broadly speaking, in every crime, there are 4 stages in the commission of an offense. These are: number 1, intention to commit the crime; number 2, preparation to commit the crime; number 3, attempt to commit the crime; and 4, commission of a crime. Number 1, intention. That is the first stage. Intention or ideation to commit the crime. This is the initial stage where the individual forms the intent or idea to commit a crime. Refers to the mental decision or desire to commit a criminal act. The law, however, doesn't usually punish mere intention because it exists only in the person's mind and is difficult to prove unless expressed through actions. Additionally, mere intention without an overt act does not cause any harm to society. For example, A considers robbing a bank. A person considers robbing a bank. He thinks about it and imagines how he might carry out the crime. However, he hasn't taken any step towards executing it, and at this stage he cannot be legally held accountable for just having the idea to rob a bank. Preparation to commit the crime. The preparation stage refers to acts or steps taken in preparation for committing a crime. In this stage, a person begins preparing for the crime. This could involve gathering tools, resources, or planning how the crime will be carried out. However, preparation alone is generally not punishable unless the law explicitly states so for certain crimes. In most cases, the law requires that the preparation advances into an actual attempt to make the crime punishable. The Bharatiya Nyaya Sanhita 2023 continues to hold preparation as not generally punishable except in the case of serious crimes such as Section 149 of BNS 2023, preparation to wage war with the Government of India, Section 178, counterfeiting currency, and Section 310, preparation for committing dacoity, and preparation for terrorist acts. This reflects a consistency with the traditional legal principle that mere thoughts of or initial steps towards committing a crime should not be punished unless they pose a significant threat to the country or public order. The purpose is to balance individual freedom with public safety. Punishing individuals who prepare for dangerous crimes while avoiding criminalizing thoughts and minor preparations for less serious offenses. If an act remains confined to the first two stages, there is in general no criminal liability. If intention and preparation were made punishable, it would be impossible to prove that the object of an accused was to commit an offense. That is, a person might purchase a gun for self-defense. It is in the third stage that the liability arises. Whether the act is in second stage or it has entered the third stage is a matter of evidence. Third, attempt to commit the crime. Attempt is the direct movement towards the commission of the offense after the preparations are made. To constitute the offense of attempt, there must be an act done with the intention of committing an offense and for the purpose of committing that offense, and it must be done in attempting the commission of the offense. An attempt can only be manifested by acts which would end in the consummation of the offense, but for the intervention of circumstances independent of the will of the party. An intervention of circumstances independent of the will of the party, an attempt to possible even when a person intending to pick another's pocket thrusts his hand into the pocket but finds it empty. If the attempt to commit a crime is successful, then the crime itself is committed, but where the attempt is not followed by the intended consequences, Section 62 of BNS applies. Thus, A stoops down behind a rick of corn and lights a match, intending to set the rick on fire, but discovering that he is being watched, he just sits down near the rick, takes out a cigarette, lights it and blows it out the match. Here the act of lighting a match was a direct overt act converting preparation into attempt. A has thus committed an offense of attempt to set fire to the rick. For example, A, intending to murder Z, buys a gun and loads it. A has not yet committed any offense. A fires the gun at Z. He has now committed an offense. A, intending to murder Z by poison, purchases poison and mixes the same with the food which remains in A's keeping. A has not yet committed the offense. A places food on Z's table or delivers it to the Z's servant to place it on Z's table. A has now committed the offense of attempt to commit murder. Difference between preparation and attempt. Preparation consists in devising or arranging the means or measures necessary for the commission of the offense, whereas attempt is the direct movement towards the commission after the preparation are made. An attempt to commit an offense is an act or series of acts which leads inevitably to the commission of an offense, unless something which the doer did not forever happens to prevent it. Unless something which the doer did not foresee happens to prevent it. An attempt is made punishable because every attempt, although it fails to succeed, must create alarm, which of itself is an injury, and the moral guilt of the defender is the same as if it had succeeded. Moral guilt must be united with an injury to order to justify punishment. But as the injury is not as great as if the act had been committed, only half the punishment is awarded in case of attempts under Section 62 BNS. Commission of the crime. The fourth stage in the commission of the crime is that it is successfully committed and the consequences of the crime materialize. The offender is awarded the punishment prescribed for the offense in BNS.